everybody, and thank you for coming along today. What I'll do first of all is just introduce myself and Michelle, who is on the screen there for you. And then, I'll just sort of outline what we're going to talk about this morning and in what order. And then we'll, get underway. All right. So, as you know, today is all about assessment. Today is all about assessment. Now that you've been here for a few months, no doubt too, you will have developed questions that you would like to ask, and there'll be plenty of time for questions this morning as well. And after we've had a general talk about assessment, I know we have a lot of students in the graduate certificate or our master's programs in the room. After we've talked about assessment generally, you people will be able to leave. You can stay if you want, but you'll be able to leave, because the last part of the session this morning will talk specifically about exams, and that will be more relevant to the LLB and the JD students who will have exams in a lot of their courses. But of course, master's students and graduate certificate students, you don't really have exams, so you don't need to stay to that part of the session this morning. So yes, first of all, as I said though, let me just introduce myself and Michelle. So my name is Wayne Morgan. I'm the Associate Dean Education for the college. And in that role, what that means is that I am ultimately responsible for our educational programs. And I also approve things like the assessment requirements and guidelines for our programs and our courses when I need to look at them individually. And I also, conduct our academic integrity investigations when academic integrity investigations need to be conducted. And so, all of those important things about your programs, your assessment, and academic integrity, I'm heavily involved in, okay? And so that's why I'm the one who will be giving you a lot of the information this morning. But as well as myself, we're very lucky to have with us another very experienced member of the academic staff of the law school, and that is Dr. Michelle Worthington, who is on screen with us. Now, Michelle is here for a couple of reasons. One, she is also very experienced in terms of matters of academic integrity. And also, sometimes I delegate to Michelle my responsibilities for conducting academic integrity investigations. So again, Michelle has a lot of experience there. But also, apart from that, and this will be, again, particularly relevant to the LLB and the JD students, Michelle, for many years, has taught in our first-year programs. And so helping the first years prepare for particularly exams. And so when we get up to that part of the session this morning, I will, hand over to Michelle to talk specifically about, exams and preparation for exams. And, at both parts of the morning, though, while I am speaking generally, if Michelle has something to say, she will, interrupt and contribute, and vice versa. When Michelle is talking about exams, if I have some point that I want to add, thank you, Rose, I will, interrupt and do that. So that's generally what we'll be talking about this morning, all right? And so as I said, and because we have so many students with us who are master's students or who are students in the graduate certificates, I want to talk a little bit about research-based assessment tasks, because that is mainly, of course, what you will be asked to do. And after talking a little bit generally about those research-based assessment tasks, I then want to say a few words about some issues that we have been having problems with in recent times with some of our students. And some of those specific issues are artificial intelligence and artificial intelligence programs. Also, the use of translation programs. And after I've said some words about those, then generally speaking, some other points for you to remember about academic integrity. Because yes, the standards that we have with respect to academic integrity may be different from what you are used to in your previous study, particularly if you were graduate students. All right, so that's what I want to talk about first of all. As I said, before we get up to the academic integrity issues, let me say a few words about research-based assessment tasks and what will stand you in good stead. What will be good things for you to remember when you are engaging or have to submit research-based assessment tasks in your programs. So what I have to say in this part of this morning applies to all of you in master's courses, those of you in the graduate certificate, but also those of you in the LLB and JD programs as well. So I want to divide this into two sections. What we mean by research and what sort of research you should try and do. And then also a few words about legal writing and what we expect in terms of the legal writing, all right? One thing I want to make clear at the beginning though, obviously everything that I am saying is at a general level because I'm trying to make it applicable to all of you and to many of your courses. You should always, of course, pay specific attention to anything that your convener says, right, about any of the assessment tasks, and to also any material that is published or podcasts that are recorded that give you advice specifically about the assessment tasks. Now, we do have conveners who do these sorts of things in some courses, and it's really in your interest to listen to those. I recently had to speak to a student about one of their assessment tasks, and they told me that they had read none of the resources that were put on the Waddle site about that task. And obviously that meant that they ended up with quite some problems. So yeah, don't avoid the obvious things, right? Don't think you can make those sorts of shortcuts because you cannot. All right. So everything I am saying this morning, obviously, is subject to the specific things that your conveners say in your courses. All right. A few words about research. Now, obviously, this will vary slightly in terms of the area of law that you are studying and any advice that your convener gives you about research, but a few of the basics. All right. So first of all, we expect you, when you're conducting research, to do that research on credible legal sources. All right. So what do I mean by credible legal sources? Obviously, you will have some primary sources, and by primary sources, we're talking about legal documents that are drafted for legal reasons. So in other words, things like legislation or laws that parliaments or legislatures might make. We're talking about cases, judgments that courts might decide. But we might also be talking about government documents, or indeed documents produced by international organizations, all right? So those are all the sorts of things that we mean by primary sources. Now, in whatever area of law you are studying, you will have to look at primary sources. And you will have to get used to reading them and interpreting them and understanding them and referring to them in your essays, right? Or your other research-based tasks. What we like to see in our research-based tasks is a student who can both quickly and accurately summarize what one of these official documents says, but then can also critique it. Tell us what is good about it. Tell us what is bad about it. Tell us what needs to be improved. Tell us what would improve the legal regulation, or critique it in some other way. For example, critique it as against a set of criteria or even a theoretical perspective. All right. So what does this document look like from the perspective of Indigenous people? What does it look like from the perspective of feminists? You know, so there could be a whole lot of different depending on what your convener asks you to do. But that's what we mean by primary documents. So learn to read them, understand them, summarize them quickly, and critique them. So that's one part of the sorts of research you'll be doing. The other part is looking at what we refer to as secondary legal sources. And what we're primarily referring to here is credible experts who have written about a legal issue or legal documents, and preferably who have had their work refereed and published in a credible journal or a credible source. All right. So again, depending upon the area that you're studying, there will be specific types of legal academic journals that you should be looking at. And with every area of law, you will be able to find this. So whether it's international law, whether it's corporate law, whether it's intellectual property law, whatever it might happen to be, right? You will find specific academic journals that write about the issues of law, all right? And that's the sort of sources we expect to see you research, to refer to, to cite in your essays, and to rely upon, all right? We don't want to see lots of Google sources. Now, of course, you'll find some of these academic journals that I'm talking about, you'll be looking them up online, right? And that's fine, you know, that's absolutely fine. But in terms of when you cite them, you will be citing to the journal, to the author, to the journal, to the page, right? And yeah, if you found it online, you might include the site where you found it as well. But that's not what I mean by Google sources, all right? That's fine. What I mean by Google sources is just random things that you find on the internet that might happen to be discussing the issue that you are researching, all right? If you don't know who that author is, if it is not in a credible journal, if it has not been refereed by other academics or experts, well then don't use it. Or at least think very carefully about using it and what you are using it for. All right? So yeah, credible expert sources is what we want in proper journals. Now, let me say a word about sort of newspaper and magazine reports, all right? Sometimes it will be appropriate to refer to newspaper and magazine reports, but you should never refer to it in terms of expert analysis of the issue, right? You would be referring to that newspaper or other, you know, journalistic source as an example of what the media is saying, an example of popular commentary. So you can refer to it for those factual reasons, right? This is what the media says about a particular issue. Or this is the sort of coverage that it received in newspapers or in popular magazines. So you can refer to it on a factual basis, but you should never be using those sources in terms of your analysis of a particular legal issue, all right? For the analysis, it's those other sources that I've referred to. The refereed journal, published sources by experts, by academics, by people who are knowledgeable in their field. All right, now that's the major things I want to say about your research sources. But, you know, when we get up to questions, anybody can, of course, ask me any questions about, what is expected in terms of, research sources. Michelle, did you have anything you wanted to add about research sources?
No, not from me, Wayne.
Okay, fantastic. So now let me say a few words about writing and what is expected in terms of the writing. Again, before I get up to the academic integrity issues. And let me just take a sip of my coffee before everything. Now, obviously, again here, you should pay careful attention to what your convener or your other teachers say, because there are different type of assessment tasks that will require different types of writing. Now, I can't cover all of those this morning, but yeah, let me just talk about a couple. And the most important, of course, is a research task that asks you to analyze a particular area of law. All right. So that's one of your major ones. And of course, that will often be the case in a research essay that you are asked to write. Now, another, but this is more relevant to the LLBs and JDs, so I won't say much about this at the moment, but I will say a little bit because sometimes in master courses you have to do it as well. A case analysis, right? So taking a particular judgment and having to tell us something about that judgment. The third type I'll say a little bit about is the more reflective type of assessment tasks. And in that category, I would put things like blog that you might be asked to write, particularly in your master's courses, or reflective essays. Sometimes you'll be asked to write a reflective essay or a reflective paper. So they're the three main types, all right? So because I don't want to say this much about case analysis at the moment, I'll address that one first. But what we mean by a case analysis is, first of all, you must be able to, as quickly as possible, summarize the main points of the case or the judgment and the principles of law that it stands for. All right? But summary is only ever one part of a case analysis. Once you've done the summary, which of course must all be properly referenced, particularly if you're quoting from the judgment that you are summarizing, once you've done that, you will then be asked to analyze that case or critique it or assess it against a set of criteria, whatever it is that the convener has asked you to do, all right? It might be any of those things. And then, once you've done your brief summary, and keep that as brief as you can, covering all of the main points, then proceed to do that analysis according to the criteria or the perspective or the methodology that the convener has asked you to do. So sometimes, for example, and I'll just give you a couple of examples, it might be, all right, well, explain to us how this case fits in with this area of law or other cases decided on this topic, all right? So if it's that type of case analysis, yeah, you will be expected to be able to tell us, well, in this area of law, the principles have often been thought to be X, Y, and Z. This case simply develops those principles. It is consistent with the decided cases, or it, progresses a particular point of law in the specifics, whatever it might happen to be. So you're assessing it against other decided cases, particularly those that have gone before, all right? And of course, if this case has substantially changed or taken a different approach to most of the other cases that have been decided in the area, well, then that is what your case analysis should focus on, right? How it is different to or has changed the law from what went before. As I said, apart from that type of case analysis, you might also be asked to assess the case against a specific set of criteria or a specific perspective. If you're asked to do that, stick very closely to the criteria that you have been given or the perspective that you have been told to assess it against. So I can't say very much specifically about that today because that will vary, right, according to the criteria or the perspective that you have been asked to assess it against. But whatever that is, you will always be able to find resources to help you. And if you are having difficulty finding the sort of academic, refereed, journal article resources that I have referred to, The librarians in the law library are always there to help. And yeah, they love to talk to law students about how to do their research and to where to find their sources. All right. So yeah, even if you're in one of our master's degrees that's with another faculty, like the Master of International Law and Diplomacy, and even if you spend a lot of your time, in the College of Asia Pacific, remember, for your legal research, you're very welcome always in the law library, and the law librarians will always help you, all right? And give you guidance about where to find online the right sort of journals and the right sort of things that you should be looking for. All right, so that's all I want to say about case analysis. Reflective pieces that you are asked to write. Now, as I said, this might take the form of a blog, or it might take the form of a reflective essay. Again, I won't say much about these because they'll vary according to the course that you're in. But obviously, if it's reflective, there will be something that you are being asked to reflect on, all right? Which will either be a particular piece of reading, or it might be the classes that you have attended or gone to, all right? Now, the important things about a reflection as opposed to a research task, which I'll get to at the moment, is that in a reflection, the convener really wants to hear your thoughts and your views, all right? Your reflections on the particular piece of reading or the classes. Now, when I say they want to hear your views and your thoughts, that doesn't mean that it's completely uninformed and whatever you want to say, all right? We want you to tell us what your views are, but we want you to tell us why and what they are based on, right? And so that's where, again, you might start to bring in more academic sources that might be referenced in a reflective piece that you write, okay? If it's a reflective piece about a particular article, you might say, I really agree with this point and this point in the article. Here are my reasons for agreeing with it. Here's what those reasons are based on. But I really disagree with this point and this point. And this is my reasons for disagreeing. And here is what my disagreement is based on in terms of my sources, all right? So that's what we mean by a reflection. And if it's a reflection on classes, often what the convener wants you to do is to reflect on your knowledge or understanding of the area at the beginning of the course before you start it, and then how that has changed throughout the course or the classes that you're being asked to reflect on, referring to the readings and the class discussion as you go. All right? That's, I hope, a bit of a description about what we expect with reflective tasks, whether they are blogs or reflective essays. Finally, research assignments. And remember, these might not always be written. And these days, we're trying to be a little bit more creative. So sometimes, for example, you might be asked to record a podcast, which is still a legal analysis, all right? So the same sorts of things I'm about to say apply as to whether it is a written task or an oral task, something like a podcast, or indeed a presentation. Sometimes you might be asked to make a presentation in class, all right? So the same things apply to all of those. Now, I won't go back over the research. I've talked about the sort of sources that you should use. But in terms of how you put your presentation or your essay or your podcast together, the most important thing, and I know this can be difficult if you're new to law, and so it'll take a while to develop, but what we look for most is an argument, right? We want an argument. We do not want a description, and we do not want a set of unrelated points, okay? We want an argument. So your introduction should tell us what your argument is. Again, it's hard to give you a specific example because I don't know what you're all studying and what it might, be. But for example, in an essay question, you might be asked whether you agree or disagree with a particular proposition of law or particular area of law or a particular principle. So you should clearly state in your introduction what your view is. And then you should argue throughout your essay, establishing what your view is. All right. So backing up, supporting, building on to reach your conclusion. So having taken into account everything that I have written throughout my essay, the evidence that I presented, the arguments that I put forward, therefore my conclusion is. So, we want that argumentative style, which is connected throughout the essay. So, as I said, even if you've got sort of separate points that you want to make, think about the interrelationship between those points and how best to present them as a flowing argument. All right? Because as I said, what we don't want to see is a list of dot points. You're asked to comment on a particular issue or a particular area of law, and you say, on the one hand, on the other hand, or, these are the positive points, these are the negative points, but all of those are more or less independent. You don't use them to develop an argument throughout your essay. And, your conclusion is a bit wishy-washy, or you sit on the fence, without really telling us anything about the argument that you have come to based upon your sources and your reasoning and your logic and your legal knowledge. All right? Okay. Look, I now want to get on to, and I'll ask Michelle first if she has anything to add. Some of those problems I've mentioned in terms of artificial intelligence, translation programs, and a few comments about academic integrity generally. But Michelle, do you have anything you want to add?
No, Wayne, I thought that was wonderfully comprehensive.
Okay, thank you. All right, so, and these really, the next couple of things I'm going to say, I can say fairly quickly, because basically, although we can't prohibit their use or, ensure that you never use them, my strong advice to you is that you should not use artificial intelligence programs, and you should not use translation programs. If, despite my advice, you do use those things, you must acknowledge in the work that you hand in that you have used them. And if you do not acknowledge it, and we discover that you have used them, you will be in trouble. It will be an academic integrity issue. All right? And that may mean that you will either have to have a meeting with the convener, or more seriously, if it's worse, you'll have to have a meeting with me, or possibly with Michelle. You could be faced with penalties, which can be anything from we won't impose any extra penalty, but obviously it will affect the mark that you get for the essay. It can be, that's at, the really minor end, or we can impose a mark penalty on the assessment task. I can decide that you should therefore get 0 for that task, which might mean it's very difficult then for you to pass the course. Indeed, I can impose a penalty that you should fail the course. I can even go beyond that. Obviously, it wouldn't go beyond that unless the case was incredibly serious and you had done something which was definitely cheating and definitely fraudulent. But I can go all the way up to excluding you from the university, right? So yeah, I can't emphasize enough how important these issues are. All right. And I'm not saying this to scare you. Okay. That is not my goal. Okay. My goal is so that you learn the behaviors and the practices which mean you are a contributing and successful part of an academic community. All right. So, and that you do get good results in your assessment tasks. All right. So that's the goal. Okay. It is to help you, even though I might sound a bit like a bad cop in some of the things that I'm going to say. All right. Yeah, it is in your best interest. So yeah, first of all, translation programs. Lately, we have had problems with students who are writing their assessment tasks entirely in their own language and then putting them through a translation program and submitting what has been spat out by the translation program. All right. Now, as I said, you should not do that. If you do, despite my advice, if you do, you must acknowledge it. Your first footnote must say, I wrote this in, and tell us the language in which you wrote it. I used this translation program. You must tell us all of that. And if you don't, and if we discover you, yeah, it will be an academic integrity issue. The reason why you shouldn't use it, there are a number of reasons, and I'll give you some particular examples, particularly when we're talking about legal essays. Most translation programs are not good at translating, particularly legal terminology or legal concepts. So what the translation program might spit out might end up making absolutely no sense to your marker at all. You know, I'll give you an example. It might not make sense to all of you, but this is literally from, you know, something that happened, one of our students. There is a legal concept in the common law that we know as unconscionability. Now, you know, even that word, what does it mean? You know, you would have to look up. You would find out what it meant in our legal system by doing research in those legal journals I talked about before, right? But the problem was, yeah, someone had to write an essay about this. They used a translation program, and it translated this word as unreasonableness. Unconscionability has nothing to do with unreasonableness, right? So despite it from being, yeah, an academic integrity issue, and I'll tell you why that was in a moment, despite that, it also meant that the person wasn't answering the question, right? And therefore could not get a good mark. It was an academic integrity issue because, remember, the basic requirement in terms of the assessment task that you submit and what you have to sign every time you submit something in Turnitin is that this is entirely your own work. If you put it through a translation program, you know, a translation program is not like a spell checker or a grammar program, right? Which shows you where something might be wrong and gives you the choice of changing it. That is still your own work, right? But a translation program does more than just, you know, translate individual words. If it just did that, it wouldn't make sense, all right? So it is not your own work, or it might not be your own work if you have put it through a translation program. And that's why you must acknowledge it if you use one. And if you don't, yeah, it will be an academic integrity. Now, of course, you can use a translation program, look up a particular word, but yeah, you should never write an assessment task in a foreign language and then put it through a translation program. Never. Now, I know for some of you, you might think, well, you know, perhaps my English skills aren't very good. and maybe they need to improve. And I know you're all busy. I know that. But remember that the university does offer programs, classes, extracurricular things that you can do to improve your English. But my strong advice to you would also be, you're only going to get better, particularly in academic English, by learning to write in it, okay? So don't be worried about, particularly if you've just started your program, if you're in your first couple of courses, if it's all very new to you. Don't be worried if your marks are not very good, or even if you might fail the first couple of tasks, okay? It is still much better to write in English and have the marker say, you need to improve your English, right? It is much better to do that than to use a translation program, or even worse, buy an essay off one of the essay buying sites or whatever it might happen to be, and submit that instead, all right? Because, improving your skills is a process. But if you take my advice, you will improve and your marks will go up, all right? I guarantee it. So, write in English from the beginning, even if this means at the beginning your marks are not very good. All right, that's translation programs. Artificial intelligence programs. Now, again, I can't say everything I would like to say. I don't have time. But a few key points. First of all, the reasons why you should not use them. One, they are often wrong. Okay? They are only based upon the databases that they have access to. And that stops at a particular point in time. And also, it might mean that they have better access to some sorts of databases than others. So, for example, the AI programs are not very good on Australian law, right? Now, I'm sure they'll get better over time. But at the moment, if you ask them a question about Australian law, the chances are the AI program will get it wrong. Okay? So that's the first reason. They get stuff wrong. The second reason is that they make stuff up, which is even worse. So you might have seen newspaper reports, and some people have even called them hallucinations by AI programs. And there was a recent example of this in New Zealand. A law firm used an AI program to do some research, asked about cases that were relevant to this legal issue. The AI program gave it some case reports and some references to cases, which looked very real. They were in the right language, they were in the right format, they referred to the right type of reports. So then the lawyer who was doing the research wanted copies of these judgments. So he went to his librarian and said, can you get me copies of these judgments? The librarian told him, none of the cases exist. None of them are real. The AI program had literally made them up on the basis of legal knowledge it had put together from God knows what database. All right? So that's the other reason why you should not use artificial intelligence programs. The third reason is it's likely to produce the sort of work that I told you before we don't want to see in a research essay. In other words, an AI program is likely to give you some dot points. It won't be good at constructing an argument for you. All right? So that's the other reason. The final reason is that, and you might be aware of this too, there are more and more detection tools becoming available. And your work might be put through a detection tool. And if it tells us that it looks like this has been produced by an artificial intelligence program, well then, again, we won't use that solely to think that you've done something wrong, but it might mean we investigate your work further, right? So yeah, for all of these reasons, you should not use them, not in terms of writing your assessment tasks, but if you ignore my advice and you do use them, you must put that in your first footnote. You must tell us that you have used one. You must tell us which program it is that you have used, whether you have used it for your whole essay, in which case you'll probably fail, or whether, certain bits, all right? You have to tell us. And now again, there is more and more material out there about how you reference an artificial intelligence program if you use one. And again, the librarians could help with that, all right? But my strong advice is don't use them at all. The times when you might use them, and they might be useful to you. So this is not about writing an assessment task. It's just about understanding something, right? So if a lecturer or your reading has referred to a particular concept and you don't quite understand what that concept is about, well then, yeah, it might, but note I'm only saying might, it might be useful to ask an AI program what that is about. The problem with that, even doing that, is what I said before. Sometimes AI programs get it wrong and sometimes they make stuff up, right? So that's the problem with even helping, using them to help you understand. But yes, with caution and with a critical approach, you might be able to use them for that purpose, all right? But never, ever should any words that have been produced by an artificial intelligence program make their way into one of your assessment tasks. All right, finally, and I'm not going to say much about this because I'm sure you've heard about this, and I know you had a session on academic integrity earlier this year with academic skills, but any of you can ask any questions you want. Let me just make a couple of other points about general academic integrity matters. Because the sorts of things we still run into problems with, particularly with new students who may not be used to our system, all right? So the first one is, and this is a really simple thing, but it's really important, the use of quotation marks, right? If you are using exact words from a source, you must use quotation marks. It's not enough just to have your footnote saying where you got it from. If it's a quote, if it's the exact words, you must use quotation marks. And it's a breach of academic integrity if you do not, right? Just while we're talking about quotes, you should never use really long quotes. Not because that's an academic integrity issue. That's not an academic integrity issue. But that might mean, you're not going to get a very good mark because it's not much of your own work, right? So your quotes should never be more than a couple of lines. You should never use a quote unless an author has said something in a particular way that you want to refer to in your analysis, right? Otherwise, what you should be doing is summarizing and paraphrasing. And that should always be your own work. Don't look up or use how someone else has summarized. Your own words, all right? So when you're taking your notes, and you should take notes on your research sources, and you don't have to take notes on every paragraph. Don't do it that way. It would take too long and it's too slavish. But read a piece and think about, okay, well, what are the main points this author is making? And how would I summarize each of those main points? And you could do that then by going back to the text, right? And maybe sticking in a couple of quotes and make sure you put quote marks in your notes when it is a quote. But otherwise, just think about how would I summarize this, and, try and do that in your own words. All right, but when it's a quote, you must quote it. Apart from that, yeah, where you are getting your ideas, and it's quite fine. We expect you to research, right? So we expect your ideas and your analysis to be based upon what you've read. Okay, we expect that. So there's no trouble with that. But yeah, you must have the correct footnotes. And again, usually in law courses, unless the convener tells you otherwise, we will expect you to comply with the Australian Guide to Legal Citation, right? The AGO. And again, this can be a complicated system to learn if it's the first time that you're learning it. And again, people like academics, like the librarians can help you if you're not quite sure how to cite something. Academic skills can help you as well, all right? So remember, there are resources out there. But yes, you must have the reference. And remember, you must have the exact page where those ideas came from, what we call the pinpoint site. All right? So if it's a quote, always use quote marks. But if it's just ideas that you're taking or summaries, yeah, have the reference in the correct form and have the pinpoint. Also, unless your convener tells you you don't need one, include a bibliography, right? So at the end of your essay, a research task, you should have a bibliography, unless the convener has said you don't have to have one. All right. Look, that's all I'm going to say on issues of academic integrity. We'll say some more when we get up to talking about exams. But remember, you can ask any question you want. Now, before I hand over to the group to ask any question that you want, I'll ask Michelle if she has any other general points she wants to make about translation programs, artificial intelligence, or academic integrity.
No, not from me, Wayne. Once again, I think you've done a really good job on all of that.
All right. Okay. So now, and as I said, we'll let the master's student or those in the graduate certificate, those in the master's degrees can go after the Q&A session. Of course, you can stay if you want to hear about exams, but otherwise you can go after the Q&A session. And then for the LLB and JD students, we'll say some more things about exams, all right, particularly because you've got exams coming up. So first of all, any questions at all about anything that I have said so far this morning, or anything, that you want to ask about any of those issues? Say an academic integrity issue that I haven't covered, or about translation programs or artificial intelligence or whatever. So any question at all, here is your chance, right? So yes.
And I know, that there is an application that fixes all the typo and grammar. Can we use it, or we have to do an acknowledge also?
So, sorry, what is it? What were you asking whether you're allowed to use?
So there's an application that fixes our grammar, typo, and that's it. Do we have to acknowledge that?
Does it directly alter your text, or does it give you a choice that you have to choose? So it highlights something that's wrong. And it gives you a suggestion.
Yes,
that's okay. All right, that's okay. Be careful though, just be a little bit careful about how often it is trying to change and how much of that you are automatically incorporating, right? So it might be good practice, for example, to look at the mistakes it's highlighted, but rather than just clicking on the suggestion it gives you, think about, all right, how do I fix that mistake? Rather than just clicking on their suggested answer, right? And after you've thought about how would I fix that mistake, then you might have a look at what their suggested answer is, right? So that will help you learn, you know what I mean? But yes, it is okay to use those grammar programs. It's okay to use spell checkers, all of those things, it's okay. But if you find that, 3/4 of your essay, it's telling you needs to be corrected, well, then I would be perhaps having an appointment with academic skills, or going to some extracurricular activities that might help me to improve my writing style. And
perfect. Thank you.
Other questions? Yes.
Hi, so I'm in the Master of International Law and Diplomacy, which the College of Law shares with the College of Asia Pacific. So far for my first semester, because I'm in my first semester, I've been familiarizing myself with the citation styles of that college, which is a completely different context. And I understand that it is either a footnote or in-text citation.
Yes.
I am completely unfamiliar with the Australian Guide to Legal Citations.
Yes.
I just want to ask right now a trivial question.
Yeah.
Is it inherently only a footnote style citation?
Okay.
Or
Generally in legal stuff, yes.
okay.
Yeah, legal writing and legal sources do not usually use in-text citation. But again, this is something you can always check with your convener, right? So some law conveners might say, yeah, I don't mind if you use in-text citation. That's what you're used to. Others will say, no, it's important that you learn legal citation, and I want to read your notes, right? So yeah, very much take your convener's advice if you're unsure. My other bit of advice to you would be, it sort of depends, and you might not know, but it sort of depends where you see yourself ending up. For example, if you think in the future you will be doing a lot of writing that you would like to be read by lawyers or like to be read by people in the legal field, well, then I would suggest that, yeah, you take the opportunity to try and get familiar with, those legal styles of referencing, because, that's what will be expected if you do work or write in that field, okay? So, yeah, it partly depends, but, yeah, you can always ask a convener, is it okay if I just use in-text citation? In most of your law courses, you'll probably be told no, but, yeah, you might be told sometimes it's okay.
All right.
Right? And by the way, the Australian Guide to Legal Citation, it's free. It's all online, right? And again, yeah, it can take a while to get your head around. But almost anything you want to know, it's a typical legal document. There will be a rule for just about anything you want to know, right? And you can search it, do a text search. So hopefully it won't be too difficult to find a particular answer in the AGLC if you wanted to know how to cite a particular legal source or how to write a particular citation in a legal footnote, right? Yeah, so hopefully.
Thank you.
Yes. Other questions, particularly from any of our graduate certificate or master's students? Like I said, now's your opportunity. And there is no question that is too basic or simple. You really can ask me or Michelle absolutely anything that you like. But if not, I'll also give you that opportunity, as long as I'm not swamped. You know my name. I think it was given to you in the emails. So Wayne Morgan, Michelle Worthington. If you have questions that you don't want to ask here today, but you would like to ask us, you can send us an email, all right? And we will try and help you. But the best advice I can give you, even the master's students, is don't think you have to work all this out on your own, okay? You don't. Both within your courses, but also places like academic skills. There are places you can go, there are people you can turn to get help. And if in doubt, ask, right? And the final thing, I cannot emphasize it enough. I know there's a lot of pressure on all of you to get good marks, right? But it is much, much better to try and do everything in English, even if at the beginning that means your marks aren't so good. Because as I said to you before, believe me, they will improve. And you will end up much better for it in the long run, even if you have a slightly lower GPA than somebody who perhaps has cheated and hasn't been caught. Right? And also think of it from a moral point of view, all right? You know, what sort of a person do you want to be? I think that's really important as well. All right, I'll give you one last opportunity to ask any questions from the master's and graduate certificate students in particular. Okay, so yep.
So oftentimes when I do research, I bump into articles, lecture videos. Is it a podcast? Is it okay to cite those?
So they're certainly not the best source. All right. So again, your best source is what I referred to before: refereed, academic or expert written articles in proper journals, which are academic journals or are professional journals in the area, right? They're your best source. If you do find something in, say, a lecture or a podcast, I suppose my next question would be, how credible and how well known is the person giving the lecture or the podcast, right? So if the person giving the lecture or the podcast was, a Nobel-winning scientist, or some very well-known professor from, a credible university, well then yes, it probably is okay. If it's just some student that you found on YouTube explaining a concept, I wouldn't, right? So again, learn to try and assess for yourselves. Don't view all sources the same, all right? Try to learn to assess for yourselves the academic credibility of the sources that you are finding. And the more academically credible they are, the better they are to cite, right?
For credibility of sources when you're doing research, how do you determine that? Because when I go to, for example, Find Online, there's a lot of the American journals that up. So sometimes I'm going to use Google Scholar.
Yes.
There's a column on the side and it says view at ANU.
Yes.
So I know that those are the databases that ANU subscribes to.
Yeah.
So that's sort of like a check to be, okay, that's an okay source.
Yep.
And then the other way that I manage that is looking at how many times the article has been cited.
Yes.
So I wonder
Those are all yes. Those are all good. Yes. Yes. Yeah, I agree. Those are all good ways to check credibility. Just bear in mind though, just because the ANU has it, and of course, the more and more that you study or work in your field, the more knowledge you will have about experts in the field, about people who are well respected in the field, who write a lot in the field, right? So bear in mind that even the ANU will have sort of like different levels of sources. It has more journalistic sources as well as the really important and well-respected academic journals, right? So, but unfortunately, the only way to sort of get used to these things is by practice, right? Or by looking, up. There are some things like there are sort of lists of journals in terms of those that are regarded as the really, top-notch ones, so you can use some of those. Google Scholar is a good source. And things like how often are they cited? All of those are good ways to check the credibility, the academic credibility of those authors that you might wanting to be relying upon. Michelle, do you have anything to add about that?
Yeah, it's a really good question. And I agree, Wayne, your point about it takes practice and there are a few indicators which can be helpful, which are never going to kind of answer the question for you completely. Another idea I do have is that sometimes it can be really useful to try and find the rock stars in a particular area by using contemporary textbooks on the subject matter. So really high quality textbooks on a particular area of law may cite certain people who have been influential commentators on an area of law in their own textbook. So that might give you an indicator of who is a really authoritative source. The writers of those textbooks might themselves also have articles out there that you would be happy to look at because you've seen the fact that they know enough about an area to write a credible textbook. And the other thing is too, sometimes some articles, the point of them is to kind of provide an overview of what's called the literature in an area. So that is a whole range of different work that other academics or other scholars or other lawyers have produced on a particular issue. And the point of the article, this literature review article, is to sort of summarize all of that stuff. if you can find those kinds of articles in a particular area, they are really very helpful in helping you to sort of get to the heart of who it is that's very influential in a particular area of study. So there's some additional ideas that I have. And in relation to finding the literature reviews style articles, if you wanted to, you could have a chat to our lovely law librarians around how you might be able to locate that kind of resource, and they can give you a hand with that.
They also might sometimes be called review essays. So, rather than an article in a journal, they might be a review essay that's doing what Michelle's talking about there. Thanks.
Fantastic. Thank you so much, Wayne. And hello, everybody. I'm sorry I can't be there with you in person today, and I hope that the connection is good. And let me know if you need any help getting closer to the board or if there's any problems with my audio as we go through. Okay. So today I've structured this talk around 3 different things, or 3 different aspects of the exam experience. The first thing I want to talk about is thinking about exams. I just want to have a quick chat about framing and how you can do your thinking about exams in a way that's going to make you a little less stressed potentially about the exam experience. The next thing we're going to chat about is preparing for exams, obviously a big part of the exam experience. And then the final thing we're going to chat about is some important things to remember during the law exam. So that's the basic structure for what I'm going to take you through today. After that, we're going to have hopefully time for questions at the end. If you do have a question as we go through, please feel free to let me know. I can't see everybody in the class, so you might have to go through lovely Wayne or someone else who's here.
Yeah, exactly. So yes, put your hand up and I'll let Michelle know that someone's got a question.
Yeah, perfect. That's great. Okay, well, let's get started. So in terms of thinking about exams, I have a question for you. It's not a trick question. This is a real question. How many people in the room actually enjoy sitting exams? Does anyone have their hand up?
Nobody has their hand up. Although,
okay.
Michelle, I was tempted to put mine up. I didn't enjoy them at the beginning of law school, but by the end of law school, yeah, I sort of enjoyed them.
Yeah, great. I'm so happy to hear that, Wayne, because I would put my hand up. Like, they're not my favorite thing to do, but actually they can be quite enjoyable as a challenge. So one of the things I want to talk about first is the possibility of taking some of the pressure off yourself around law exams by framing the experience of sitting the exam perhaps slightly differently to the way that you are doing so already. So for those of you who don't greatly enjoy sitting exams, and this is obviously a common experience amongst you, something that I think might help with the experience of sitting the exam is framing the exam as an opportunity for training. We tend to think of exams as a peculiar experience, as kind of unique in their structure, unique in what it is that you're supposed to do. But actually, if you think about them in context, they're really just like a particularly tough training session in what is an overall pattern of training that you're going to be undertaking in the course of the law degree. So it's an opportunity for you to learn. It's an opportunity for you to practice your skills, particularly the critical legal skills of understanding where legal issues arise on the law and the facts, being able to put on the page your well-considered answers to what you think legal problems are that arise on the law and the facts, and to do so in a persuasive way. So it's really a very condensed, quite intense training session. It is there for your benefit as much as anybody else's. It gives you the opportunity to really hone these critical legal skills. And I think this is a perfectly plausible framing of the exam experience, even though it sort of doesn't really feel like that. Usually it kind of feels like you're performing, or it's some kind of thing that you have to get right. But I think if you take the pressure off yourself a little bit and just realize that actually this is just part of the overall training experience that I'm having in the College of Law, that might help you to feel perhaps a little less pressure around the experience. The other thing that I think is really important to remember when you're going into a law exam is that there is no such thing as the right answer to legal questions. Now, hopefully you've encountered this idea before in your legal studies, and this isn't the first time you're hearing it, but if it is, it's an important thing to understand. There is no such thing as capital R right answers to questions of law. Now, that's not to say that law is just this nihilistic, relativistic discipline where you can just say anything and get away with it. That's not the case. It is absolutely true that there are wrong answers to legal questions. There can be categorically wrong answers to legal questions. But what we're looking for in an exam, what you are trying to produce for the marker, is well-reasoned answers on the law and the facts. I'll say that again. Well-reasoned answers on the law and the facts. That is the essence of legal argumentation. That is the goal. That's the target that you're looking for. So there's no such thing as perfection in legal reasoning. There's no such thing as the right answer, the only right answer. There are usually a number of different ways that you could reason your way to a persuasive conclusion at law. And bearing that in mind when you go into an exam, it really helps to take the pressure off because you have a lot of control over how you approach the questions. You have a lot of control over the experience of sitting the exam and formulating your answers. And I think that that's something that's really worth bearing in mind. So it's not like, am I going to get this wrong, right kind of, theme the line you need to tread during the exam? It's usually not like that. There's usually a whole field of answers which are available to you. And then you just have to select the ones that you think are the best. I find that very reassuring in the context of sitting legal exams. The other thing I think that might help you in terms of taking some of the pressure off yourself around assessments is to understand that in many respects, the law assessment, particularly the end of semester law assessment, is not really about you when you consider things in context. And I'll just explain what I mean by this. For many of you, your legal studies will be an entry path into the legal profession. So it will give you the opportunity to go ahead and to practice law if you wanted to go on and be admitted as a legal practitioner. As part of that process, of course, the law school is teaching you the skills that you need, the knowledge that you need to become a baby lawyer in the workforce. And we verify via your academic transcript to admissions bodies, so the people who are responsible for admitting new lawyers into the profession, that you have a base level of skills commensurate with your experience in the law as a student. So in a sense, these exams are not really about you. They're about the people that you're going to be helping in future when you go into the profession, if that is something that you do. It's about you having these base level skills and knowledge so that you can actually assist people well and competently when you become a practitioner, if that's something that you want to do. So it kind of takes you out of the picture. This isn't about you so much. This is about safeguarding the quality of legal advice. And if you've ever been to a lawyer, or if you imagine that you'll need to see a lawyer at some point in your life, and basically everybody does, you're going to want your lawyer to have these skills. You're going to want your lawyer to have the ability to actually help you. And in order for that to happen, we need to have these systemic controls, I suppose, quality controls in place in the law degree. And of course, law exams are a really important part of that systemic control. So once again, it's not really about you, it's about the bigger picture. It's about you moving into a profession if you want to, and being able to do that with confidence, knowing that you're going to be able to be a real assistance to people with their real life problems when the time comes. The last thing I wanted to say about thinking about exams is to give a plug to this book. I've never met this author, so there's no there's no kickbacks here. This book is called Mind Set, and the author is a woman called Dr. Carol Dweck. This is an incredible resource for, I would say, everybody, but particularly people who are starting their law degrees. So I recommend this to all of my first semester law students. It's an amazing read. Basically, I think this is a helpful roadmap written very clearly as to how you can approach being a learner in a really productive way. So law school is difficult, including because very often people come to law school with very highly developed skills, perhaps even at the top of their game in another profession, and it's very difficult to start again as a beginner and a learner. This is a really fantastic resource. It will definitely help you in preparing for and sitting your exams. Don't go and read this if what you should be reading is your torts or foul materials in preparation for the exam. But when you have time, definitely pick up a copy of this book and give it a read. I'd recommend it enough. Okay, that's all I wanted to say about thinking about exams. Did anybody have any questions about any of that?
No hands in the room, Michelle.
Okay, great. Thanks, Wayne. Okay, well, let's move on to preparing for the exam. Okay, so first thing first, when you are preparing for the exam, the most important thing you need to know initially is, what is the exam? So you need to get clear about the exam, the nature of the exam. Now, Wayne mentioned earlier today a conversation that he'd had with a student where the student hadn't accessed any of the materials in the class that was relevant to an assessment task. This is sadly not an isolated experience. I've had a similar experience with students. Material about your assessment tasks, including your end of semester exams, should be in your class summary. So you can find this on the wall page for your course. Have a look at it, read it, ideally look at that and read through it in great detail at the start of your course. It's not too late. If you haven't looked at it already, you can go and look at it after this session, and it will include information about the nature of the exam at the end of semester. So things that you want to note as early as possible in the semester are things like, what is the examinable content for the exam that you're looking at? So very often, conveners will structure their assessment tasks to map particular parts of the semester. So you want to be clear on what content you're being taught in the course is actually being assessed in a particular exam. There's no point in revising material that's not going to be examined in the exam. That's not a good use of your time for the exam. So definitely get clear about examinable material. The other thing that you want to get clear about is format. Is it going to be an online exam? Is it going to be an in-person exam? Is it going to be a multiple choice exam? Is it going to be a classic legal problem exam where we give you a fact scenario and we ask you to solve certain legal issues that might arise using the law that we've taught you in the course? Is it essay-based? Is it open book? Is it closed book? You want to get a sense of all of these things because that is going to help you prepare your notes and prepare your understanding for the exam, because you would prepare very differently for different kinds of exams. So you definitely want to get clarity around format, and you should be able to do that quite early on in the semester. The other thing that's critical, this might sound like really obvious, but people get this wrong, including, I have to admit, myself when I was an undergraduate student on one very memorable occasion, dates and times. You need to be clear about this. Dates and times. On dates and times, for the end of semester exams, and this is often also the case for mid-semester, you might not know the dates and times at the start of semester. This is usually a planning process that happens during semester. And the university goes through this process of releasing a draft exam timetable and then a final exam timetable. So you won't know until you're further into the semester what the date of your exam is going to be. But keep a really close eye on your emails, keep a really close eye on Waddle, because announcements should go up about when the drafts and final timetables for your exams, which will contain date and time and location information. Particularly important if this is an in-person exam, you want to get across all of those things. So make sure you are actively looking for that material. Don't just wait for your lecturers to tell you, because they might assume that you are on it. So make sure that you are actually putting in your diary at different points a reminder to check information about the exam. The other thing that you need to be clear about is citation requirements for the exam. Now, I'm going to speak about this specifically later on in today's presentation. So I'll just mark that for the moment as being very important. Wayne's given you lots of really helpful information around citation in things like essay-based assessments, but we're going to talk about it specifically for exams as well, because that can shift a little bit. Okay. So as I said, most of this should be available in your class summary on Wattle, except potentially date and time and location information, which comes later. Make sure you're across this if you can be. All right. Can I just get a sense of who's read their class summary? Has everyone, if you could put your hand up if you've actually gone into Wattle and read your class summary. Oh, good. I see one hand. That's encouraging.
Yeah, most people in the room have their hand up, Michelle.
Oh, well done, Steve. That's great. Okay, that's better than normal, by the way, so well done. Okay, so that's all I wanted to say about get across the details. So understand the format, understand what kind of exam you're going to be sitting, because this will guide the way that you prepare for the exam. In terms of general preparation, things that would apply irrespective of the format of the exam that you're going to be sitting at the end of semester, you want to stay on top of your material. So one of the things that you've probably noticed about your legal studies so far is that the law is voluminous. There is a lot of it. Part of the challenge of being a law student is just staying on top of your reading, making sure that you're getting to class. It's a lot of work in a law degree. So staying up to date is a huge help. Don't cram. So you might be used to cramming, particularly if you have come from perhaps another discipline or another degree where you're really confident with how things go in that area and you're sort of on top of your game and you feel like you can shortcut the process of preparing for exams. Don't try it in law. This is a high-risk strategy for everyone in the law simply because there is so much in the law. It's so big. It is just it's just a physical impossibility really to get across a lot of a semester's work in a short period of time. There's really only so many hours in the day, so you need to try and get across this as much as possible. Wait, did you want to say something?
Yeah, could I just make a point there? The other reason not to cram at the end is because part of doing well in an exam is learning to think like a lawyer thinks in that area of law, all right? And that might vary from area of law to area of law. You can't cram that at the end, right? Even if you're listening to all the lectures at the end, you can't cram that. It takes a while for it to sink in and it takes practice throughout the semester, right? So yeah, that's another reason not to cram.
Fantastic. Thanks, Wayne. That's a really good point. I actually think that some of this stuff won't really start making sense until right at the end of semester, particularly when you get to equity, where there's some very, very difficult concepts. So great, great point, Wayne. Thank you. And we know that you're here in no small part to get to know Australia and to have a wonderful experience in a different culture, a different place. We want you to go exploring. We want you to have fun, but don't forget about your class. Okay, so go to class, very helpful. Don't cram, stay on top of the material. And I'll be interested if Wayne has any comments to make about this. But one thing that I found really helpful in keeping up with the material, because it is a real challenge, how do you stay on top of the reading? Something I found really helpful was to do the reading after I'd listened to the lectures. So to listen to the lectures, do the reading, because the lectures should sort of tease out the more important parts of the reading for you. Obviously, if there's a reading set, the convener has set it for a reason and you're supposed to read all of it. But the lectures should help you sort of, I guess, identify the major points that you really want to take from a particular week's work. So I used to listen to the lectures first and then do my reading. And I found that helped when I kind of flipped around. Because when I started out, I started reading first and then I go to the lectures and it just wasn't as efficient. I thought this was really helpful. If you can, depending on how your tutorials are structured, if there are tutorials, the thing to do is to listen to the lectures, do your reading, and then go to your tutes. it's a bit hard to go to your tutes and to get as much as you can out of your tutes if you haven't done the reading and listened to the lectures. So you kind of want to have both of those things in place if you can. But if you can make it happen, doing it in this order might be something that's worth trying. Up to you, just an idea. Okay, so in terms of keeping on top of your work, something I want to talk about, a related idea, and you've probably heard about this, is the idea of the law summary. Can I get a sense of who in the room has started preparing a summary for any of their classes? Has anyone heard of a summary? Is anyone preparing a summary?
We've only got a couple of hands up in the room.
Okay, fantastic. Good, thank you. So the legal summary is, I suppose, the foremost tool that students of law have to help them prepare for their end of semester exams in particular. So I'll just explain what a law summary is and give you a few tips about how you can develop your own.
And I think, can I just add, for those of you who are in Foundations of Australian Law this semester, Judy Jones, your convener, has also talked about this issue, how to prepare a summary. So obviously, yeah, make sure you listen to what Judy has had to say about preparing your summary for Foundations of Australian Law.
Brilliant. Thanks, Wade. And I think that was in her week 7 lecture. So if you want to check it out, definitely check that out. So in terms of what a summary is, you might have guessed from the name, a summary is intended to be quite a distilled version of your notes from the course, which is put into a format where you can easily access content, find it in an exam, refresh your thinking about a particular issue, a particular state of the law, you know, what happened in a particular case. It's really a sort of aid memoir for the exam. Most of your law exams are going to be open book, and this is for the simple reason that the law is too big to keep in your brain. Sometimes you might have a closed book exam, but they're going to be pretty rare, to be honest. So you can prepare, in preparation for the exam, can take into the exam this distilled version of your notes, which acts as an aid memoir for you, a kind of map in the exam where you can see the whole course in front of you and you can navigate your way around different issues as they might arise on facts in the course. Now, it's up to you as to how you would craft a summary. There's no formula. You know, it's not like this is what a law summary has to look like. Things to think about when you're developing your own summary are, how do you like to learn? If you are, for example, a visual learner, then you should incorporate diagrams, flowcharts, that kind of thing into your summary. It's going to help you keep the law in your mind in a kind of holistic way. Are you somebody who's like super details focused? If that's the case, then, well, maybe you're going to want to have part of your summary, which is actually a little bit more getting down into the weeds about different areas of law and not just very high level, that kind of thing. It's actually very useful to think about how you like to learn and then design your summary accordingly. But basically, what I would recommend as a pretty good general approach to creating the summary is that you want to have, at a minimum, I suppose, an overview of the main topics that you've covered in a particular course. So, for example, if you're going to the Foundations of Australian Law Statutory Interpretation exam, which you will be if you're sitting FEL, then things that you would want to know about would be, text, context, and purpose, for example, is the modern approach to statutory interpretation. Maybe what you would do is order your summary according to the different topics. Text would be like one big topic, and then you could put lots of information there, everything you've learned about the different principles of law around actually working with the textual rules of interpretation. Context would be another important topic. You would put all the rules there around context, what context is allowed to be brought into statutory interpretation, the authorities that you would use to rely on that. CIC insurance, by the way, if anybody's wondering. And then, of course, purpose. You know, how is the purposive approach understood in the context of statutory interpretation? And that would be like a nice general 3-point structure for your summary, and then you could populate it according to the different subtopics that come under those main topics. Get what I mean? So you have to identify the particular topics under discussion. You want to include going to make more room on the board here. You want to include a useful description of the main principles of law or the rules that are applicable in relation to particular topics or subtopics. You also want to have at your fingertips the relevant authorities. So maybe there are cases which are particularly important as authority in a particular area. Maybe there's legislation, so provisions from an act. You want to have them listed next to the particular principles and rules that you're trying to summarize. You might want to include short case summaries. So just a brief description of important cases that arise in the case law on a particular topic. Include a description of the facts and also, of course, how it was that the court sort of resolved the matter in brief. Something I really recommend that students have at the end of their summaries as well is an index. So you want to draft your summary so that it's easy to navigate. Put page numbers on your summary. Use paragraph numbers in your summary so that you actually can jump to particular parts of your summary as necessary. You want to make this document as navigable as possible. If you have an index at the back, which just has listed basically every single topic or subtopic or issue that came up in the course, and then you put next to it like a page reference or a paragraph number reference, if you're in the exam and you have a bit of a freeze moment, you can literally just run your eye down the index after you've read the question and wait for things to jump out at you and be like, oh yeah, I think there's an issue here around implied repeal in this legislation. Ooh, okay, right. Where's that in my summary? It's at page 3. Then you can go to page 3 of your summary, read the material there, refresh your memory, decide whether or not you need to talk about it. So an index at the back of the summary is like a safety net, basically. It's like a checklist, things that you can think about. What you want to create in the summary is just a really accessible overview of the whole parts of the course that you are going to be examined on. So this is why it's important to understand what is examinable, because you don't need to produce a summary for the final exam if it's only like the last 3 weeks of the course, which are examined. You wouldn't produce a summary of the whole course if it's just the last 3 weeks. Okay, I'm just looking at the time. In terms of how you prepare the summary, it's very important that it's your own work. Now, you might have seen that other students obtain materials online. Maybe you've even got a friend who's told you that they've bought a summary online. I cannot caution you enough against doing that. That is a very, very, very bad idea. Wayne, you wanted to jump in there?
Well, only when you finish, Michelle.
Yeah. So what I recommend that you do is to develop your own summary using your own lecture notes, using your own notes from your reading. Pull that material into your summary and make sure that everything in your summary is your own work, except for, obviously, any quotes that you're getting from cases, but you would want to include in your summary where that's come from, usually as quotations. Anything that's come from legislation, you want to include in your summary where you're extracting from legislation. You can include in your summary commentary about the law that you've got from, say, a textbook in the course or another person, or indeed the lecture materials or the slides. But you have to include them in your summary as having come from this other place. Because sometimes what we see students do, and sometimes the way that students can get into problems in academic integrity senses in exams, is that they prepare their summaries, but they don't do it in a mindful way. They just kind of vacuum material in from lots of different sources, and they don't note for themselves in the summary where they got it from. And then they reproduce, unwittingly or unintentionally, material developed by another person in their exam, which is plagiarism. So you have to be careful about making sure that your summary is your own work. I recommend that you don't buy summaries from the internet. Develop it yourself. You'll go through the process of learning. You get that benefit, obviously, and also you'll avoid any difficulties with academic integrity. Wayne?
Yeah, exactly. I just wanted to emphasize this is one of the most common areas of academic integrity I have to deal with. So constantly at the end of the semester, I am calling students in. This is if they're submitting their exam online, but even in script books, we can tell. So even if you're handwriting, because something that they have written, and you may not be aware of it if you bought a summary or copy somebody else's summary, something that you've written in the exam is actually from a different source and you didn't know it was from a different source. We know it's from that source, and that means you're in breach of academic integrity. Or another thing that happens if it's an online exam, and if you've bought a summary or used one that you've found floating around the internet, even if you haven't bought it, or the ones that circulate in the residential colleges, right? We know that happens as well. What'll happen is Turnitin, but again, even if it's not online, we can often tell this in the scribbles, will say that your answer matches another student's answer, or possibly 3 other students' answers, or 5 other students' answers. And so then, of course, we might suspect you of doing something that you haven't done, and which is worse, and that is copying someone else, right? But at the very least, if it's matching up as you're using the same, you've got the same words as somebody else's answer, we're going to call you in, right? And often that will reveal that, yeah, those 2 people didn't copy off each other or anything like that, but they used the same summary.
Yeah.
All right. So for all of those reasons, yeah, what Michelle said is really important. Produce your own summary. Back to you, Michelle.
Fantastic. Thank you, Wayne. Okay, so that's all I'm proposed to say about summaries. I want to talk about pre-prepared material, but I'll come back to that, I think, during the exam. Actually, no, I'll talk about it now. Going back a step. This is not all I want to say about summaries. I got one more point. So this just builds on what Wayne just said, and I want to clarify something in case the question has arisen in your mind. The question might be, can you ever pre-prepare material that you would then put into an exam? Could you put into your summary, for example, a description of the law, which you yourself have developed? So it's your own synthesis of reading the cases, reading the legislation, listening to the lectures, reading the textbook. Could you prepare your own summary of descriptions of the law, which you could then copy and paste into either an online exam or an in-person exam? The answer is yes. But, and there's a huge but based on what Wayne just said, very important, it has to be your own work. And you have to be sure about that. You must be totally across where that content has come from, and you must be confident that it's all your own work, except for, of course, quotations that you would take from a case, which you would include as quotations and say they came from the case, or legislation that you're taking from usually Commonwealth law, but maybe not, might be state or territory law, which you would also include as legislation as well. If it's your own work, sure. You would only do this in relation to descriptions of legal principles, though. So yes, you can pre-prepare material. It has to be your own work, and it's only going to really be descriptions of legal principles. This is because if you are sitting, for example, a classic sort of legal problem exam, and you're using the HYDRAC methodology, what you would be able to use here is in the statement of the relevant law, you could pull in this pre-prepared material and save yourself some time in the exam. But a huge part of what you're actually doing in any kind of legal problem-solving exercise is not just identifying the relevant law, but applying it. Most of your marks happen at the A stage of HYDRAC and also the I stage, identifying issues. Neither of these things you can do before the exam. Both of those things happen in the exam. So do not ever attempt to pre-prepare analytical material or material that you would put into an exam other than descriptions of relevant legal principles. Wayne?
Look, we know we said 12 o'clock. Some of you may have classes or other appointments. If you have to leave, leave, right? But for those of you who want to keep, we'll just keep going for a little while, to complete. But yeah, if you have to leave, leave. And yeah, I just wanted to emphasize again what Michelle just said, your application, right? Your issue spotting and your application. Sometimes we get exam answers where the students go, pages and pages or paragraph and paragraph about what the law is. All right. It's a waste of your time. Be succinct about your statement of the rule and spend as much time as you can on your application. Go on, Michelle.
Brilliant. Thank you. So that's all I propose to say about summaries. Now what I want to do briefly is talk about other things that you can incorporate into your preparation, which can be very helpful. So the first that I would recommend is past exam papers. So the library will have, or should have, a repository of some past exam papers for you. If you can't find any in the library, talk to the convener from your course and ask them if you can get a copy of exam papers. They don't have to give them to you, but hopefully they will. Doing past exam papers is the best way, I reckon, to prepare for an exam, including because it helps you to understand how examiners think about a particular area of the law. Because there are certain patterns which tend to kind of come up, in variation, but generally speaking, recognizable patterns in terms of how you're assessed in particular areas. The best possible way you can do past papers is to attempt the past papers under exam conditions. So do them in the time that the exam was set for, pretend it's the exam, write it out exactly as if you were in an exam. Apart from anything else, you're going to get practice doing hierarchy. You're going to get practice with your English language expression, but also it helps you to identify where the gaps are in your knowledge and also where the gaps might be in your summary as you're developing it for the exam. So past exam papers, absolute Olympic standard preparation technique. The other thing that's very helpful I found when I was in law school are published summary study guides. So the big legal publishers like LexisNexis and Thomson Reuters tend to have series of pocketbook, I suppose, summaries of an area of law. Like you can get it for torts, criminal law, statutory interpretation. And the point of these summary guides is for students to be able to understand what the main principles of law in a particular area, and usually also what the most important cases and legislation are. So they're like a mini, very, very distilled textbook written by legal experts, which are incredibly useful. You might be able to get some at Harry Hartog. If they're not at Harry Hartog, just Google sort of student study guides. But we're talking about published ones. We're not talking about ones that you get from other students who've uploaded them on the internet. So you're looking for LexisNexis or Thomson Reuters are the publishers. They're usually around $30, $40, $50, and I think they're usually really worth it. Okay, I think in terms of preparing for the exam, that's all I wanted to say. Let's start with my
one other quick point. Look, I agree. Those published study guides can be useful, but can I suggest, and sometimes a convener will write this into the exam question, where you can always use cases or legislation or references that have been referred to in class.
Yes.
All right. What we want to see is how much you have learned and absorbed from the class. All right. So sometimes those published summaries might include cases that haven't been covered in class. Right. So that's my only word of caution. Try and use the sources and the cases and the legislation that has been used in class. Okay. Yeah.
Great. Thank you, Rachel. Please. Wonderful. Okay. So during the exam, now I'm going to split this discussion up into in-person exams versus online exams. And we're going to start with in-person exams. Okay. So in-person exams, some really practical things to remember. And, sometimes, I was sort of so focused on learning the law and you can actually forget about this stuff. First of all, you need to think about, date, time, location. I've said it already. Can't say it often enough. Know where you have to be and when. That's very important. If you've never been to the location of the exam before, consider doing a little recce journey before the day of the exam so that you know how to get to the location and you're not trying to find it in stressed conditions on the day of the exam and getting lost. So know where you have to be. If you're also there in person, think about what you can take into the exam. So there are some things which are permitted, things that are not permitted. It will depend on the nature of the exam. If it's an open book exam, which is usually the case, you can take in anything really except ANU library books, and also certain prohibited electronic devices. So you can't take in your laptop, you can't take in your phone, you can't take in your tablets, etc. But there's really kind of no limit other than those things as to what you can take in terms of written materials. Do not swamp yourself, however. So be a bit thoughtful about what you would take in and make sure that you've checked the rules around what you can take in, because some conveners might actually say that there are things that you have to take in or not take in. And the ANU actually also provides this information in the examination office website, or part of the website, which you can Google and get clarity around. But generally speaking, for an open book exam, there's a lot of stuff you could take in. So we're going to talk about what you should take in. Wayne.
Yeah, just one thing about the electronic devices. Be careful about digital watches.
No, wait.
I thought if there is a clock in the examination venue.
Yes, there will always be a clock in the examination venue. And in fact,
I have a regular watch which broke down.
oh, okay, yes. You can have an analog watch, an old-fashioned dial.
I do have, but
Like, you cannot have a smartwatch because that could be a way to cheat, all right? So remember to take off a smartwatch. There will definitely be a clock, but also if it's an in-person exam, the invigilators, the people who, are in the exam room with you, they will often write on a board at the front what the time is, or they will write, 15-minute intervals and they will cross them off as the time goes, all right? So even if the clock is in a location you cannot see, there will be a board at the front and the examiner will cross off as the time expires, all right?
Great, thanks. I hadn't thought about smartwatches. Good pickup. Okay, so in terms of things that you could actually take in for an open book exam, don't drown yourself in material, but have a good amount of material. So what I recommend that you take in are your textbooks from the course. If there's any legislation that you really focused on in the course, you should take in a copy of that legislation. If you have your summary, hopefully you've got your summary, take your summary. So those would be 3 things in particular that you would want to take. I would also recommend taking an English language dictionary. You might want to take a dual language, English plus another language dictionary into the exam to help you understand words that might come up in the text of the exam question. That's a useful thing to have as well. And, if there's any other thing that you've been working with that you thought was really helpful to help you get across the material as an aide-memoire, you can take that in as well. But you've only got pretty little desks, so bear that in mind too. There's not a lot of space. Take 3 pens at a minimum. Make sure that all of them are working before you go. You need your student ID, so make sure you've got that. You can take in blank note paper if you want. You will get some scribble paper from the invigilators when you're in there, but if you are a particular scribbler, like you write a lot, then maybe you would take some of your own blank paper in. That's fine. In terms of food and water, they've actually kind of made this a bit more strict over the years. You can take in a bottle of water in a clear bottle, but nothing else. So sadly, no snacks, which is a bit grim, but anyway, wear comfy clothes. I once wore pajamas to an exam, recommend. And remember your glasses. If you wear glasses, don't forget those. In terms of online exams, really important things that you need to have in place are a reliable computer, a reliable internet connection. Put your phone or other devices, maybe smartwatch, in another room to help you concentrate and to avoid distractions. Turn off notifications so that you're not being pulled away from the task at hand by these things that pop up on your screen. Have a quiet space. Be by yourself, preferably. Have the dictionary. That's useful to have it. And also, of course, the same amount of written materials that I spoke about before. You want your texts, you want legislation if it's relevant, you want your summary, etc. Remember that with your exams, unless specified otherwise, your exams are going to be individual assessment tasks and you cannot speak to any other person during the exam, particularly online exams, where you could potentially wonder if you should text your friend. The answer is no. You cannot be communicating with another person during the exam. The other thing I want to talk about, and I might end on this point given the timing, is time management. So this is a critical skill that you can only really get practicing exams or sitting exams, which is part of the reason that doing past papers is so helpful. So time management, absolutely critical in the exam. It doesn't really help you to know a huge amount about the law and to be a really effective communicator if you can't do what you need to do in the time that you have in the exam. So in terms of time management, when you first get into the exam, you need to have a time plan. So you need to figure out how many questions there are. You need to figure out what the weighting is for each of the questions. So how many marks are allocated to the questions. And then you need to do a little bit of basic maths. Now, I know that law students are often not very comfortable with maths. Don't panic. It's usually a pretty straightforward calculation. So if you had a 2-hour exam, it's 2 questions that were both equally weighted. Let's say they're both worth 25 marks. Then you would spend 1 hour each in the writing time for that exam on each question. You have to have your plan in place for time before you start. And it is critical that you stick to the plan. So if you're on question 1 in this hypothetical exam where you've got 2 hours, 2 questions, 1 hour each, if you're on question 1 and you get to 1 hour and you haven't finished, you have to move on to the second question. Do not keep writing into that question. Give it up. You've done everything you can in the hour that you had. You must move on. This takes real discipline. It feels wrong. You have to do it. Believe me, it's the best thing that you can do. So have your plan and stick to the plan. It's critical. Speaking of plans, the other thing that you want to do, which will help you enormously with time management and just the efficacy of your answer generally, is that you should have a plan in place for your answer before you start writing in earnest. Hopefully you can do this in the reading time, particularly for an in-person exam, but you want to have a plan. The plan doesn't have to be hugely detailed, but at a minimum, I think what you would need to have in the plan is the ultimate issue that you need to answer for a particular question. So the question that you're trying to answer, and then in the order that you would address them, the sub-issues that arise for consideration. You don't necessarily have to have the answers to the issues at that point. You just need to know what you have to talk about, the order in which you have to talk about it, and then you can start writing. So ultimate issue and sub-issues. Wayne.
Yeah, just really quickly, I wanted to make the point that law exams, the in-person ones, will often have quite a good reading time, okay? And just in terms of making your plan, and I agree with Michelle, they're crucial. And yeah, you can do that in the reading time, but you can't do it in the script book, all right? You're not allowed to write anything in the script book during the reading time. And that's why they will always give you a bit of paper, or why it's a good idea to take in with you scribble paper, as Michelle said, because that's where you write your plan during the reading time, okay? Go on, Michelle.
Perfect. Thank you. Actually, Wayne, can I just keep you for a second? I wanted to say a bit about citation in exams. I think it's quite important, but given the time, do you want me just to record a little video and upload that?
What would people in the room prefer? Would you rather that Michelle just quickly said what she's got to say? Or, yeah, I'm seeing a few nodding heads. And now again, if you have to leave, leave. All right? But otherwise, yeah, Michelle, keep going.
Okay, fantastic. Thank you. All right, so
we'll try and do it quickly, but yeah, keep going.
Great. So in terms of citation for exams, so everything that Wayne said before about citation in your assessment tasks, particularly those that you do over a period of, say, days or weeks, which involve AGLC4 citation, all of that is correct. The thing to note is that in your exams, because they're time limited, we often relax the citation requirements so that you don't have to use full AGLC4 style citation, but you do need a citation style. We tend to call it exam style citation, and I'll just explain what that is. So the first thing to note about this is that exam style citation may change course to course. So you need to understand what your convener understands is the citation requirement for a particular exam. Hopefully this will be made clear to you in the lead up to the exam, but if there is any lack of clarity, or if you're not entirely sure, please write to your convener and ask for clarity around what expectations are for exam style citation in your exam. Generally speaking, what we're talking about here are in-text references to cases and legislation that are shorthanded. Now, I must emphasize again, this is just a generalization. Different conveners might expect different things. But in my courses, for example, in exams, I will just have in-text references to cases and legislation that are shorthanded. So, for example, those of you who are studying Foundations of Australian Law and you have your statutory interpretation exam coming up, if you wanted to talk about context in statutory interpretation, and you wanted to make the point that under the modern approach to statutory interpretation, you need to think about context in its widest sense, which is a very important principle of law, you could say something like that, context in its widest sense, and then you could put in brackets just after that, bracket CIC insurance, which is basically one of the foremost authorities on context, and certainly the one that says you need to think about context in its wider sense in statutory interpretation law. And that would be a good citation. So you don't even need both of the party names. You just need to be able to identify the case. You don't need a page or a pinpoint reference number to where in the case that point comes up. So it's a very different style of citation to AGLC4 style citation, which is very precise. Exam style citation, we just really need to know that you know the source of this authority. So that's how you would in-text shorthand cite a case. It also saves you time and words. In terms of legislation, we want a bit more detail. We want you to give us the precise subsection of the legislation that you're dealing with. So, for example, I also teach corporations law. If you wanted to talk about the best interests duty the directors have to act in the best interest of the company, you would have to say section 181, but then you could just say CA. Section 181 CA, Corporations Act. I know what you're talking about. You don't even necessarily have to have the year that the act was came into force or anything like that. I just need to know that you know what it is. If there is a subsection in that section, you should also go down to that detail. So let's say what you're really talking about is section 181 1A. That's the level of precision that we do want with legislation, and there's no way of getting around that. But once again, this would be an in-text reference to the relevant part of the legislation that you need to point to in order to make good your claim about the law. And generally speaking, that kind of citation will suffice. So generally speaking, we're looking at shorthand in-text citation. Don't worry about footnotes. Don't worry about AGLC for precision. We just need to know the relevant source of the legal authority and that you're representing it correctly. Importantly, if you refer to any sources in your exam that are secondary sources, so they're not case law, they're not legislation. So maybe you wanted to pull in a quote from a commentary piece, like, I don't know, a really good article you'd read about an area of law, for example, by a respected commentator on the law. You can do that sparingly, but we need to see where that comes from. So you might need to put in a bit more detail about the source material there so that we know exactly where you've got it from. And if you're using quotes, you have to use quotation marks like Wayne said before. So you need to give us a bit more information if you're drawing from secondary sources, which is going to be more unlikely than primary sources. But just make sure that anything that is in your transcript that is not exactly your own work is represented to us in a way that we can understand where it comes from.
Could I just quickly interject there? So, yeah, in a problem-solving exam, it'll be mainly the primary sources we want, cases, legislation. So, yeah, you would hardly ever refer to a secondary. If there's an essay in an exam, then obviously you'll be using more secondary sources. You can still use shorthand, but it must be enough so that we can find it. All right? That's the important thing about the shorthand. Yeah, we must be able to find the source by what you tell us. Go on, Michelle.
Perfect. And then just one last thing I think that's very important about materials included in your exam. We often provide you with quite detailed slides and lectures in your particularly doctrinal compulsory legal courses. One way that students can get into trouble, particularly academic integrity trouble in their exams, is by just reproducing that material into their exam transcripts. And not just the quotes from cases or the quotes from legislation that might appear in the slides, which is fine. You can reproduce that material when you tell us that it comes from the case or tell us that it comes from the legislation. But where students can get into trouble is where they just copy and paste the lecturer's own commentary on the law into their summaries or even just directly into their exams. We do not provide you with commentary on the law so that you can just give it back to us. We want you to synthesize the material that we give you in classes. We want you to put it into your own words. We want you to explain concepts in your own words. If you are just copying and pasting commentary on the law from slides that your lecturer has given you and putting that into your transcripts, that can get you into difficulty in terms of academic integrity because it's not your own work. Now, different conveners might have slightly different approaches to how relaxed they are about the use of their slides, but I would urge caution, and I would say that you should only ever be including in your transcript your own words as your own words, and if you're ever using material that's written by somebody else, that has to come in the form of a quotation if you're actually using those words that you've taken from somewhere else, including if they come from the slides. And it doesn't look good if you're reading an exam transcript and it's just like quote from the slides, quote from the slides, quote from the slides. That's not going to get you very good marks because you're not synthesizing the material. You're not demonstrating that you're able to make your own arguments, perform your own analysis on the material that we've given you. You're just giving us back usually descriptive content, which, as Wayne made the point before, is not where the marks are really won or lost in the context of an exam. Wayne, did you want to add to that?
No. I'll let you finish, Michelle. But yeah, we'll need to wind up, I think.
Great. Well, that was all I wanted to say. So that was everything that I had. And if anybody has any questions, I'm happy to stick around. I've got time.
So we will give you a chance for questions. Just one final thing, and yeah, it relates to what Michelle was just saying. Students who upload material, either their own or from courses, onto some of the student sharing sites, right? Now, not only is this a breach of academic integrity, and even if you're just uploading it, you are guilty of a breach because you are facilitating somebody else's cheating or somebody else's breach of the rules, and that in itself is a breach of the rules. But what is worse, you are also breaching copyright. And either the ANU or indeed legal authorities might prosecute you for that. All right. So I know there's lots of these sites, and particularly on a trade basis. You know, if you want to download something from the site, they encourage you to upload something to the site. Don't be tempted. All right. And if we catch you, and we catch lots of students doing it, yeah, you will be brought in for academic integrity. So yeah, don't upload anything from your courses or your own work onto these sites.